Good morning, everyone. My name is Laura Vorpsi, and I'm a lecturer at the University of Tirana, Faculty of Law, teaching international private law and intellectual property. And today I'm very happy to be with all of you in this conference. And we will delightfully present our article, also on behalf of my colleague, Mr. John Skanderi, named the EU Private International Law Framework for the Acknowledgement and Execution of Judgments in Employment Matters. The most important legislation that applies especially and specifically to labor dispute within the European Union are as below. The first one is the Brussels Regulation, secondly is the Enforcement Directive, and third is the Rome Regulation. But these are not the only ones, as far as we have also the Working Time Directive, Temporary Agency Work Directive, and the Posted Workers Directives. These are very important when we deal with employment matters within European Union, and this is the legislations that applies to fix all of those matters relating to this issue. When it comes to the European Court of Justice jurisprudence, we can easily say that it is of an enormous help because European Court of Justice has issued a significant number of rulings on the acknowledgement and execution of judgments in employment matters within the European Union. And these cases have helped to clarify the range of validity and the use of the relevant European Union legislations and have provided guidance on how to interpret and apply these standards for acknowledgement and execution in the context of employment disputes. Actually, there are four main cases of 1997, ruling in the case of Bellicer versus Hot de Seine, and this case concerned the acknowledgement and execution of a French judgment in a case involving a dispute between an employee and his employer. And the European Court of Justice held that a certain judgment rendered in one jurisdiction must be implemented in the other jurisdiction without any specific requirement or for any other steps. The decision must be binding and unconditional, and it cannot go against the public order. Another important case, as we can see here, is the 2000 European Court jurisprudence ruling in the case of Edition Jacob versus Office for Harmonization in the Internal Market. This case concerned the acknowledgement and execution of a Spanish decision in a case involving a dispute between an employer and also his employer. And the ACJ held that a decision that is given in an EU jurisdiction must be acknowledged and enforced in other jurisdictions, deprived of the need for any unusual process. However, the judgment must be given by a court with jurisdiction under the Brussels regulation. And the same goes with the two other cases, the case of 2005 Schleicher versus Begner and the case of 2017 Holterman Expedit versus Spies. So we can say that these cases highlight the importance of ensuring that employees are able to enforce their legal protections in the international setting employment disputes, and they provide clarity of the conditions that must be met for judgments to be recognized and executed in other jurisdictions. Regarding the conditions for acknowledgement and execution of judgments in employment matters in the European Union are governed by the European Union Acquis, which is the body of the European Union law that has been adopted by all European Union member states. The relevant regulations and directives establish the system in place to ensure that decisions are recognized and enforceable in employment matters across the EU. And actually, an essential condition in order to validate and execute court rulings in employment matters is that the decision must be given by a court with jurisdiction under the Brussels Regulation. And the Brussels Regulation is the main EU instrument for determining which the judiciary is able to examine a case that has a cross-border element. And another important condition is that there must be no more appeals and the verdict must stand. And what does this mean? It means that the judgment of a ruling that was issued by a court with the authority to consider the matter, and it must not be subject to appeal or any other form of review. And actually a judgment that it is not final and conclusive cannot be acknowledged and executed in different jurisdictions. The relevant European Union regulations and directives, it's completely understandable that they ensure that employers are able to enforce their rights in the context of cross-border employment disputes. And finally, it's important to note that some of the EU member states may have additional requirements for acknowledgement and execution of judgments in employment matters. For example, some member states may require that the judgment is translated into the language of the member state in which the acknowledgement and execution is sought. So, does the EU regulation on jurisdiction and the acknowledgement and execution of judgments in civil and commercial matters has a role? It definitely has a role, and its role is very important because it is the significant body or law, let's say, that regulates the acknowledgement and execution, and also it provides a framework for determining which court has jurisdiction to hear a case when we have or we're in front of cross-border matters. And it definitely ensures that employers are able to enforce their powers within the member states, regardless of where the employer is situated. For example, let's say the judgment must be final and conclusive and must not be contrary to public policy. And in addition, the judgment must be in relation to a matter that it is considered to be within the scope of European Union law. The Brussels regulation ensures that employers are able to enforce, as I said before, their rights across the EU member states, regardless where their employer is based. As far as we have a very potent and very strong regulation within the EU, which is called the Brussels 1 and the Brussels 1A, which reinforces the Brussels 1. So, said it all together, the scope of the EU directive on the execution of judgments in civil and commercial matters is because it sets out the rules for the acknowledgement. It applies to judgments given in a civil and commercial matters, including those ones regarding to the employment matters that have a cross-border element. It also aims to simplify and expedite the enforcement of these judgments in order to facilitate the free movement of judgments and to ensure that, which is very important, to ensure legal certainty for individuals and companies. It is the law that establishes a minimum set of rules regarding the enforcement and acknowledgement, but as I have said it a little bit earlier before, member states are free to provide more favorable rules for themselves. Legal assessment on the relevance of the principle of mutual trust in the acknowledgement and execution of judgments. Actually, the principle of mutual trust is a fundamental principle of European Union law and is particularly relevant in the acknowledgement and execution of judgments in the employment matters. This principle means, the mutual trust, that European Union member states must trust each other's legal systems and must recognize and reinforce judgments given in other member states unless there are serious reasons to doubt that the legality of the judgments or the impartiality of the court that gave the judgments. In the context of employment matters, the principle of mutual trust is important because it ensures that employees who have obtained a judgment in their favor in one member state are able to enforce that judgment in other member states without the need for any special procedure. As we may all know, Brexit has had significant implications for acknowledgement and execution of labor judgments between the European Union and the United Kingdom. Prior to Brexit, the acknowledgement and execution of labor judgments were governed by the European Union regulations and directives, which provided a full framework for acknowledgement and execution, including across the European Union, including the United Kingdom. With the UK's withdrawal from the EU, what we will call it Brexit, the United Kingdom is no longer bound by the EU regulations and directives, and there is no longer automatic, let's say, acknowledgement and execution of labor judgments between the European Union and the United Kingdom. As a result, there is an uncertainty about the acknowledgement and these executions. But in order to address this uncertainty, the UK and the EU agreed to include provisions of the acknowledgement and execution of judgments in the so-called Trade and Cooperation Agreement. Under this agreement, judgments given in the UK and the EU will be recognized and enforced in other jurisdictions, provided that certain conditions are met. Actually, Brexit has had significant implications for acknowledgement and execution of labor judgments in employment matters between the European Union and the UK, while the Trade and Cooperation Agreement provides a framework for the acknowledgement and execution of judgments in civil and commercial matters, including employment matters here. It still doesn't cover it all, so there is much to be done yet. In conclusion, ensuring effective and efficient acknowledgement and execution of judgments in employment matters, it's crucial for promoting legal certainty and also protecting the rights of employees in the European Union. Actually, the European Union legislative framework, including the European Union regulation on jurisdiction and the acknowledgement and execution of judgments in civil and commercial matters, and the European Union directive on the enforcement of judgments in civil and commercial matters, provides a robust framework for the acknowledgement and execution of judgments in the employment matters. Actually, the principle of mutual trust, as I have already said, plays a key role in ensuring effective acknowledgement and execution of judgments in employment matters. It promotes trust and cooperation between European Union member states, allowing for the acknowledgement and execution of judgments across the borders, which is very essential for the protection of employees' rights. Brexit, final but not least, has a significant implications for acknowledgement and execution of labor judgments between the European Union and the UK, but the Trade and Cooperation Agreement provides some framework acknowledgement regarding the executions of labor judgments between the UK and the European Union. However, there is still some uncertainty regarding the acknowledgement and execution of judgments. And to ensure this legal certainty and protect the rights of employers, it is very essential that the European Union and the United Kingdom continue to work together to establish clear and effective mechanisms in employment matters. Thank you. I wish you enjoy, and I cannot wait to discuss with you further questions and to give some answers for whatever might need it. Thank you so much.